Good morning. For those of you joining today, I'm Yolinda Bechirai, Maurice Voll Senior Research Fellow in European Law at the Bingham Center for the Rule of Law here at the British Institute for International and Comparative Law, which is abbreviated as BIICL. It's my pleasure to welcome you to this 2020 BIICL Annual WTO Conference on behalf of the Institute's director, Professor Spiros Maniatis, the Institute's trustees, and the BIICL team. We had an exciting and insightful discussion yesterday on topics such as how trade relationships will be recast in a post-Brexit world, the London panel, the WTO legacy and future multilateralism, and whether it's possible to find a vaccine using the COVID-19 analogy to ensure that reforms take place and what it will involve. This was the Geneva panel, and issues around trade governance in international global trade governance in the Washington panel, and the role of key players in this process, such as US, China, the EU. Today, another outstanding line of speakers will discuss issues around trade dispute resolution, the Hong Kong and Singapore panel, digital technology and trade, the Shanghai and Beijing panel, and last but not least, the Riyadh panel, which will address core topics related to this year's G20 summit around the theme of realizing opportunities of the 21st century for all. We are thankful to all the panelists and their chairs for taking the time to share their insights and expertise with us. On the technical side of things, for this conference, we are using the Zoom webinar format, where only the panelists will be visible to the attendees. If you have questions, and the chairs, of course, if you have questions that you'd like to raise during the sessions, you are encouraged to use the Q&A function. There is also a chat function available to message each other or to share material, refer to a case study, a journal, add a link. Please double check that you are messaging the right person. Finally, let me thank firstly our sponsors, Mayer Brown and Van Bellen Bellis, for their generous and continuing support of this event. Particular thanks must go to Professor Gabriel Marceau, Professor Malik Dalan, our BIICL trustee, and Professor Chin Lim, BIICL Honorary Senior Fellow, for their much appreciated help throughout the organization of this conference. We are indebted to them for their support and insights. And a special thanks to our events team, Liam in particular, Bradley, Carmel, Bart, who took care of the technical side of things, making everything seem effortless. Enjoy the second day of the conference. Thank you. The word over to you, Nick. Thanks.
Thank you very much, Yolinda, and welcome to everybody. Welcome to this Hong Kong and Singapore session of the BIICL conference. I'm delighted that BIICL has been able to organize the event this year. I've been a frequent attendee and speaker at the BIICL event over the years, and I know that this event makes an important contribution to the practical and academic discussions surrounding international economic law. And I think that today's event, this morning's event, the Hong Kong and Singapore panel, will be able to do just that. As Yolinda has said, we've got an excellent roster of speakers. And we're going to talk about dispute settlement and also the avoidance of disputes. And we will have three speakers: James Flett, who is a senior official at the Commission, a leading practitioner, a writer and lecturer in WTO law, and well known, I'm sure, to many of you. He will be followed by Stuart Harbinson, who is a long-standing trade policy official, very distinguished career serving as Hong Kong's representative, and also as Chief of Staff to WTO Director General Superchai, and is now with Hume Brophy. And then the last speaker will be Professor Zhangyu Wang, who is a professor at the City University of the Hong Kong School of Law, and before that was at the National University of Singapore, where he was the director of the Asia Law Institute. The full bios for the speakers can be found on the website. But as I said, we're going to start with James, who's going to offer us some reflections on the current situation and the future of dispute settlement at the WTO. So over to you, please, James.
So thanks, Nick. I think it goes without saying that I'm just offering some personal observations. I'm not speaking for the European Union or the Commission. And these are just personal observations today, and my mind is open, and I might be persuaded at some point to change it. There's no point in having a mind, my professor used to say, unless you're willing to change it from time to time. So these are just thoughts as I see them today. I want to try and move beyond what I think has become a slightly stale debate about what is going on. I will summarize it briefly as I see it, and really focus, I think, on a more interesting question, which is what does the future hold in the next few years, and specifically, how can the United States be brought back into the process, hopefully, particularly if we have a different administration. Of course, nobody knows what is going to happen. I don't think it's any secret that the US is blocking or obstructing, I would say, further appointments to the appellate body since the last few years. There is a tremendous amount of misinformation about this. This is something that started in earnest under the Trump administration. Prior to the Trump administration, surely, yes, the US was looking to shape the dispute settlement system, including the appellate body, in ways that suited the United States, but it was not systematically shutting the system down. That's something that dates from the Trump administration. I think it is important to be clear that the hawks in the ascendancy would probably not have signed the WTO agreement in the first place, and they would be adopting this course of action irrespective of anything that has actually happened in WTO dispute settlement over the last 25 years. That narrative has been intertwined with a narrative about China. I'm not going to say too much about that. I think there may well be issues with China that need to be addressed. I think the question is whether or not it is logical to break the system, or whether it's more logical to use what you've got to the extent it is available to address the issues. And there is another narrative in there about trade remedies that I would like to avoid, because I don't think we have time to go through all of that. Now, we know that USTR, for example, published a so-called report setting out a series of criticisms of the dispute settlement system, and especially the appellate body. I'm not going to deal with everything in there because it's not possible. I will say that, in my view, there's nothing in that report of any merit at all. Nothing. It's all fake news. I think the more fundamental question is whether or not, given where we are in terms of globalization, a model in which individual members of the multilateral system can conclude contracts and then break them when it suits them is a way forward for the multilateral trading system. I think anybody can see, any reasonable person stepping back can see that that's not the case. If it ever was the case, it's not the case today. And speaking from the experience of European integration over time, there really is no point in concluding agreements unless one knows that they're going to be kept. That is the whole point. Now, part of the response to the current actions of the US Trump administration has been for certain members to create the so-called multi-party interim arrangement. This is an arrangement that seeks essentially to achieve continuity, to put in place a system that's like the old system for the participating members. Now, there are 24 participating members, but that includes the European Union, which means, in fact, there are 52 participating members out of 164 WTO members. And that includes all but a dozen or so of the members that frequently litigate. So actually the significance of the NPIA is, I think, correctly stated in those terms. It's not an aggressive act. It's simply an agreement between those members of the WTO who understand that international trade law, being part of the multilateral system, and the mandatory and binding dispute settlement that goes with it, is a win-win, even when you lose. It's good for you. I mean, all people that I speak to, academics that I speak to, understand that basic point. I do think that in the long term, if you're looking at it through the eyes of an investor, you ought to prefer to set up your business plans with your global supply chains based on those members who have declared that they will comply with their international obligations. If you have a choice between setting up a supply chain between the European Union and Canada, or between the United States and China, maybe you prefer the European Union and Canada because you can be reasonably sure that the European and Canada will comply with their international obligations. And if they don't, you can do something about it. Now, I think a key question is, on what terms will the United States come back to the multilateral system? I often hear people saying that they won't. I don't believe it. I think there's a huge constituency of stakeholders in the United States who understand very well that it's in the interest of the United States to come back to the multilateral system and dispute settlement. Certainly many, many people that I speak to, academics, business, and in politics, are of that view. Now the question is, what if anything can be done? Because the Biden administration would have some constraints in that respect. I think there are things that have been identified that can reasonably be done. For example, I think it would be sensible to have 9 members of the appellate body. That would give you 3 divisions of 3. That would be perfectly sensible. I also think that the appellate body should not be interpreting context. I think context is a tool to interpret the terms of the treaty that frame the obligation and or the right that is the subject of the litigation. And a third point, which I think people would like to talk about, Article 11 of the DSU, the meaning of municipal law is not a fact. Sorry, that's just intellectually incoherent. The meaning of municipal law is the first step down the bridge of reason by which you apply the law to the facts when you construct it inductively from the specific to the general, from the law to the facts. However, one thing I think is true is that a lot of appeals have not clearly set out in the appellant's submission exactly what is the issue under Article 11. A critical fact being omitted or a fact being included that should not have been included, identify it and explain why it changes the outcome of the case. In my view, if that is not done, the adjudicator could and should deal with that point very quickly. Now, I would agree, for my taste, some of the discussions that have taken place at the appellate body level are perhaps more lengthy, for my personal taste, than would have been necessary. This is a very delicate area because it's always to some extent in the eye of the beholder. If you feel as a litigator that you've really been mistreated at panel level, you really want to have your day in front of the appellate judge. That being said, I think there would be scope to do something there. These are the kinds of things I think which reasonable and rational people under a new US administration should be willing to accept and may well accept as reasonable terms on the basis of which the United States can return to the system of multilateral mandatory and binding adjudication. If that doesn't happen, then the MPIA will go on. And I would expect that more members would join it. And I would expect that over time, what we will see inevitably is that the way it operates remains very close to the way that the existing system operated. And if I can just say one word there, one of the very live issues, a so-called issue of precedent, there is no formal binding of precedent in WTO law. Of course, all practitioners know that. USTR recently published in the New York Times the idea that we can simply have something like a spontaneous system of precedent which operates at the level of individual adjudicators at first level. So the way this works is that if a particular adjudicator is convinced by prior 5 cases, then they follow, but if they're not, then they don't. Unfortunately, this system does not ensure, of course, that the rules are going to be applied in an equal way for everybody. Now, whenever an adjudication is handed down, part of the bridge of reason will inevitably be clarifying the law, that part of the bridge of reason that is closer to the law than the facts. And the WTO is a multilateral organization. The MFN rule is the core rule. And other members have a reasonable expectation that when that same law is applied to them, it will be found to have the same meaning. That does not mean it will determine the outcome of the case, because the outcome of the case will depend on the facts and evidence in that particular case. This is why the appellate body was created, to solve this problem. I think that it's inconceivable that in a multilateral organization driven, where the MFN rule is the core rule, that it would be possible to do away with that adjudicative body whose function is precisely to ensure that the rules mean the same for everybody. I'll stop there because I would like to leave enough time for questions.
Thank you very much, James. That was a great kickoff to the debate. And thank you also for being very respectful of the time limits, leaving time for the audience. Please do feel free to send in questions. I'm sure James's presentation has provoked some questions. Certainly for me it has, but it would be nice to see some questions from the audience as well. Our second speaker will be Stuart Harbinson, who I introduced earlier. And Stuart, I think, is going to talk about trade tensions between Hong Kong and the US. So over to Stuart, please. I see a question has come in already, so thanks for that.
Thanks very much indeed, Nick, and thanks to BIICL. And I listened very carefully to the excellent reflections of James Flett at an overall level on WTO dispute settlement, which I think will stimulate quite a lot of discussion. But in the context of this being a Hong Kong-Singapore panel, I'm now going to move from the general to the specific to speak about a recent US trade action against Hong Kong, which I think has some relevance for the current WTO dispute settlement situation and also dispute avoidance. I think first I probably do need to say something about Hong Kong's position in world trade and the WTO, because that may not be very clear to all members of the audience. Hong Kong is obviously a small and very open economy, but it's a significant player in international trade. In fact, it is the 9th largest international trading economy in the world. Its world trade is slightly higher, for example, than India's or Italy's or Singapore's. As you would probably know, the WTO, rather unusually for an international organization, allows for separate customs territories as well as states to be members with no formal difference in treatment between them. Hong Kong, in fact, joined the GATT in 1986 and subsequently played an active part in the Uruguay round of multilateral trade negotiations and became one of the 123 founding members of the WTO in 1995. Following the reunification of Hong Kong, the Hong Kong Special Administrative Region with China in 1997, Hong Kong's membership continued on a seamless basis, with one change being that it is now called, quote, Hong Kong, China, close quotes, rather than Hong Kong. But to make the presentation I'm making today clearer, I'm just going to refer to Hong Kong to avoid any confusion. But where I say Hong Kong, I mean Hong Kong, China. Next, I would like to give you a quick thumbnail of the recent US action. President Trump's executive order in July 2020 said that Hong Kong was no longer sufficiently autonomous to justify differential treatment from China under various laws set out in the order. This is patently untrue with regard to trade policy, because there are very many very clear differences between Hong Kong's trade policy and China's trade policy. And there is a real border between Hong Kong and the Hong Kong Special Administrative Region and China. The executive order also states that quote, the situation with respect to Hong Kong, close quotes, constitutes an unusual and extraordinary threat to the US. But it's not easy to square this statement with the fact that up until very recently, the United States' largest trade surplus in goods globally was with Hong Kong, and indeed with Hong Kong's open door trade policy. That seems to contradict what the US has been doing in the WTO in terms of promoting the need for the WTO to have a more market-oriented membership. Anyway, the executive order suspends differential or preferential treatment for Hong Kong in a number of areas, including immigration and arms control and defense procurement, and also export controls. On trade, it includes the fact that Hong Kong products, as from November this year, should, instead of being marked as made in Hong Kong, be marked as made in China. It was originally thought that this would mean that the additional US tariffs on Chinese products would apply to Hong Kong products, but it was later clarified by US Customs that the new regulation only applied to marking and not to country of origin for the purposes of customs duties declarations. So essentially, we now have a situation in which the US is requiring that the goods produced in one WTO member's customs territory should be marked as coming from another member's customs territory, which seems not only discriminatory, but also an attack on Hong Kong's very status as a separate member of the WTO. So it's taken very seriously in Hong Kong. In fact, Hong Kong has taken up the matter bilaterally with the US and also raised it in the General Council. The US, in reply, simply restated its rationale, but indicated that it is reviewing the matter. It's not clear at this stage what sort of review that involves. Could there be a mutually agreed solution? Well, there is one obvious potential solution to this, that perhaps goods produced in Hong Kong might be marked as made in Hong Kong, China, to tally with its WTO membership status. But it's not clear that the US is interested in a mutually agreed solution at this point in time. The third point I'd like to make is that the case raises a couple of interesting questions for WTO dispute settlement. First, this is possibly the first case in which the actual basis for membership of the WTO, namely that a member has a separate customs territory, is being brought into question. And the question is, how would the WTO dispute settlement system handle such a case? Another angle is whether a perceived threat, to use the word in the executive order, from one member could justify WTO inconsistent treatment against another member. And finally, I think for the audience today, I'd like to point out that there's a UK angle in that the Sino-British Joint Declaration clearly states that Hong Kong is and will be a separate customs territory. The US, of course, is not a signatory to the Joint Declaration, but its action clearly undermines it. The question here is whether the UK might want to take this matter up with the United States, which is a close ally, but there's no indication at present that it has done so or intends to do so. Finally, two concluding observations from me. First, I think this case would be an interesting test for one aspect of WTO dispute settlement, which has sometimes been cited in a positive light in recent times, namely its ability to take politically charged issues and reduce them to technical or legal issues, and thereby diffusing tensions between trading partners. There have been some good examples of this, of course, in recent times. But this requires both parties to view the case in that light, and it's not certain, in my view, that the US does. The US may well have other priorities than defusing an argument with a political minnow like Hong Kong. Secondly, and finally, it's obvious, I think, to everyone that Hong Kong is in fact caught in the middle of a broader geopolitical and geoeconomic struggle between the US and China. Although Hong Kong has substantial trade, it has no political power. Given that context, it's not clear how Hong Kong might have avoided the dispute. We heard from Stephen Vaughan yesterday afternoon that there are limits to the extent to which the US is prepared to allow international law to constrain US trade policy. So I think I will leave it at there, and I think that indeed might be a good point to pass over to Professor Wang. Thank you very much.
Thank you, Stuart, and that was indeed an excellent segue to Professor Wang, who is going to talk about Chinese-US relations. So please, Professor Wang. I think you're still on mute.
Okay, thank you very much. I have produced a few slides because it seems that I'm more forgetful than my two other colleagues. Let me try to, okay, let me try to share the, there's something wrong here. I'm trying to share the slides, but, okay. Can you see the slides? No?
Not yet.
Okay, can I? Okay, can you see the slides?
I think they're coming up. Yeah.
Okay. Okay. Thank you very much for the invitation from BIICL, and it's such a wonderful pleasure to be among such a distinguished panel. And my two colleagues have actually laid out the general context for my presentation, and we also be talking about three major points. So the concerning the relationship between the ongoing US-China trade war and the WTO dispute settlement system. So the 3 points are: the first one is the perception of the weaknesses of the WTO is probably part of the reasons for the US to launch the trade war. And I will move to discuss the consequences, so the impact of the trade war on the dispute settlement system, and then I will look at the future to see whether there is any way out. So the first major point is whether the DSS, the dispute settlement system of the WTO, is a cause of the trade war. And from the American perspective, it seems yes. I think you're all experts and you're very familiar with the American the reasons, right? So some of them are indeed excuses. So the US allege the number one, the judicial activism. So the first one is actually, it sounds a bit strange to me because my impression was always that the US was encouraging judicial independence and even judicial activism in the WTO system, and this attitude was quite evident in the debate concerning the amicus brief issues, right? So now the US began to argue, like many developing countries, argue that the WTO is a member-driven institution, and the appellate body has overstepped its mandate. And it seems the US is arguing that more rule of law, or more rule-based system in the WTO is actually in China's favor, right? Not in the US favor. This is this is a rather curious fundamental philosophical change on the part of the U.S. And the U.S. also alleges that the DSS cannot solve so U.S. concerns in issues relating to China's unique economic model. There's some certain, actually even a strong level of legitimacy here, because China's unique economic model entails, its state capitalism, SOE, and subsidization, and state-driven development model, and very close state-business relations. So those are issues which are not yet covered by the WTO rules. But some time ago, I remember James mentioned that it's actually not the fault of the WTO, right? Especially not the fault of the dispute settlement system. So you need to, I think if you realize those are the problems, you actually should work harder to negotiate with China, and maybe WTO members can negotiate again to develop some rules rather than shutting down the whole system. And of course, everyone knows that the US probably realize if you bring complaints against China on traditional grounds such as subsidization, national security, those complaints are probably not very much winnable, right? So this is coupled with the inherent weakness in the dispute settlement zone enforcement mechanism. So those are probably the reasons, part of the reasons why the U.S. has launched trade war. Then what is the Chinese attitude? It's a rather mixed attitude, which has demonstrated a very strong degree of opportunism, right? So on the ideological front, China has indicated very strong support of the multilateral free trade, the WTO, the DSS. So the Chinese leaders, the Chinese spokesperson of the Ministry of Commerce and the Ministry of Foreign Affairs, whenever they have any chance, they will speak to support multilateralism and the WTO, right? So rhetorically, they never want to undermine the WTO. And on the legal front, China has also filed several complaints against the U.S. in the WTO, and they have won one, like the DS 543. It was a complete victory for China. The footnote is, if the U.S. brings legal action against China, they will also win. So and politically, China has launched tit-for-tat retaliations without any hesitation. So the hours and days, sometimes days after the Trump administration's imposition of retaliatory punitive tariffs against the Chinese products, China launched countermeasures, right, retaliatory measures against the U.S. products. So you see the Chinese attitude is actually quite mixed. What is the impact? What are the consequences insofar as the WTO's dispute settlement system is concerned? I think it's a major credibility crisis. I do a little bit interdisciplinary study of international law and international relations. I think the biggest blow to the WTO is credibility, right? Credibility. So you have here the two largest trading nations in the world, the two economic superpowers, almost all the measures, so the US unilateral measures and the Chinese retaliatory measures, they are naked violations of WTO law. So there's no excuse, naked violations of WTO law, complete illegality. The panel in DS 543 has concluded that the US measures are against US law, and China's retaliatory measures are prohibited by Article 23 of the DSU. So it's just a plain fact. So both countries, the two superpowers, have no concern. They have totally ignored world trade law and out of realism-driven power politics considerations. So the power politics, overrides the rule-oriented system here, right? So I think this represents a considerable level of loss of belief in the rule-based system. So something has to be done to resume the credibility, resume people's belief in the rule-based system. After all, to a very large extent, the power of law comes from people's belief. So very quickly on the future, what is the solution? One suggestion is going back to GATT, right? Going back to the GATT days. Again, from an international relations perspective, I think that might be approach welcomed by US and China as the two superpowers, right? Because the GATT approach was very power friendly and it's less rule oriented. And it also accommodates a higher level, higher degree of protectionism. But that is not good for, in the long run, it's not good for international trade. Arbitration, so that's a wonderful idea actually. And it can solve the current problems we have. And it can also serve as kind of a bargaining chip for those who support the WTO's DSS system. So in the end, probably can bring the US back to the multilateralism. And bilateral could also be another approach. So as embedded in the US-China Phase 1 agreement, but the dispute settlement mechanism in the US-China Phase 1 agreement is indeed a joke. It has nothing to do with dispute settlement, just give room for the parties to, consultation, talk, and then retaliate, right? So either by suspension of obligations or launch, punitive measures against the other party. So it's not, and bilateral approach does not seem to be, especially between the two economic powers like US and China, does not seem to be a good approach. Well, in my mind, the best solution seems to that we bring back the people's confidence in the WTO, in the current system. I don't see major problems in the current system. I don't even see judicial activism is a big issue. It is actually part of any functioning legal system, right? For the third-party independent court to develop jurisprudence, as long as it's not against the spirit, right? So, and the original, intent of the negotiators. So my hope is the new administration in the US can come back to multilateralism and focusing on rulemaking rather than trade war, right? Rather than trade war. And I also have confidence in China's participation in this process because China's reform and opening up is very much a path-dependent process. Even President Xi cannot reverse it. So even during the trade war, China appeared to be very aggressive and responded with countermeasures. But we also have to admit that during the same period, China actually unilaterally opened its economy, liberalized its economy. China made a new foreign investment law, and China allowed larger, majority ownership for foreign financial institutions. So and we also have to admit that, unlike, contrary to the very strong criticisms about China hasn't fulfilled its obligation, we also have to admit that WTO accession has changed China tremendously. Right? For people like me who followed this from the very beginning, the situation in China 20 years ago was so fundamentally different. WTO has changed China quite a lot, and one piece of evidence is actually in the last year of the Obama administration, Many in China considered TPP as a geopolitical tool against China, but they were actually inside China, inside the Chinese government. They were actually seriously considering to join the TPP and to do something to meet the very high standards in the TPP, right? So I believe not wholeheartedly, but the China is willing to take part in to embrace in the rule-making process and accept the new rules, as long as China believes that it has been given, a legitimate place in the system. So I will stop here, and I'm waiting for the questions. Thanks.
Thank you very much. I think you need to take your
sure,
slides down, please.
I'm doing that.
Thank you.
Thanks.
Very good. So thank you very much to the three speakers for excellent and thought-provoking presentations. We have a question which I think is directed at James, which is about the importance of standard of review in WTO dispute settlement. And that's from Wolfgang Weiss.
Hello, Wolfgang, and thank you very much for your question. I think the most important body of WTO law is actually regulatory law. If you look at the GATT, for a start, you can see that very clearly. This is especially the law on non-discrimination and the law on necessity. And when you look at the necessity test, in my view, it is not what we would call in the EU a proportionality test. It doesn't allow the judge to get into the question of the trade-off between the trade restriction caused by the measure on the one hand and the legitimate policy objective that's being pursued on the other hand. It's a much more limited test. It simply requires the complainant to demonstrate that there is an alternative measure, which by the way is a hypothetical, which would be less trade restrictive and make an equal contribution to the legitimate objective. That's actually quite a hard thing for a complainant to do, especially if there are multiple objectives which are concurrently relevant, because the complainant has to find an alternative measure that is less trade restrictive, but equally contributes to all of those concurrently pursued legitimate objectives. And that's quite tough. So I think there is, for this reason, if you like, a degree of deference to the regulations, the laws of individual WTO members that is structurally embedded in the most important part of WTO law. And I actually think that's the way things should be. The WTO is not some instrument of international harmonization. The WTO is premised, in my view, on the idea of regulatory diversity and regulatory competition. The only rule is that you're supposed to do it in pursuing your legitimate policy objectives in a way that is the least possible irritating to your trading partners. You're supposed to be a good neighbor, let me put it in those terms. And that is entirely consistent with the fact that there is no executive in the WTO. If you want to talk about the idea of deference in a municipal legal order, you're in the triangular relationship between the legislature, the executive, and the judge. And then you typically have a doctrine in the US, it's the Chevron doctrine, whereby the judge will not interfere if the executive's construction of the statute is a reasonable one. We have a very similar rule in EU administrative law before the European Court of Justice. In the WTO, there is no executive. And therefore, what the WTO adjudicator at panel level is doing is looking for the best fit, the best interpretation of the law, the meaning of the law that is best supported by the terms of the treaty and the interpretive cipher, the public rule, the rules of interpretation in public international law. And also from a factual point of view, it's a question of, in case they're contested, which proposition best fits the facts and evidence. I'll wrap up in just 1 second. So even though in dubio mitius, in my view, is not a principle of public international law that finds its way into the WTO system because it's a multilateral system, deference in the sense I've described is absolutely embedded in the most central part of WTO law, and rightly so. In the specific field of dumping law, of course, there's this debate about 1762 of the dumping agreement, and we know what the US thinks it wanted in those negotiations, but the problem is when you read the provision, it doesn't say that. As we know well, the appellate body case law on this point, it first directs you towards the customary rules of interpretation of public international law, and to the extent that having applied those rules, you in theory have two permissible interpretations, then the defendant will win. The appellate body has explained this very correctly, and I think it's, personally, I think that that's entirely correct. Finally, as I've been talking about standard of review at panel level, when you come to an appeal, I do agree that an appellate judge needs to be aware of the fact, aware of the question of whether or not the issue that they're looking at when they examine the way in which the panel has applied the law to the facts and built that bridge of reason with its logical structure. Are we looking at an issue that is very close to the end of the bridge, which is attached to the law? Because if we are, this is really much more of an interpretive question, and it's important that it's right. And that's clearly, if the case turns on a question like that, the appellate body really needs to address that as a point of law and resolve it to make sure that the law means the same thing for everybody in future cases. Now, there are other cases where the live issue in the appeal finds it is in fact much closer to the measure municipal law, if you like, the meaning of municipal law. And if the case turns on that question, you can ask yourself, I think at least as an appellate judge, and it's difficult because there's no bright line here. There is no bright line. That's part of the problem. Adjudication is a science, but also to some extent an art and a feeling. If you're looking at that kind of case, you need to be aware as an appellate judge. You need to be asking yourself the question, do I need to intervene here? Am I looking at an issue that's important for the entire membership because it's at this end of the bridge of reason? The answer is yes. You probably need to satisfy yourself that you think that the law is being interpreted correctly. Am I looking at an issue at the other end of the bridge of reason? To what extent can I look at what the panel has done and really see it as, let's say, seriously problematic? If yes, then justice must be done and you probably need to intervene as the appellate judge and reverse. But if it's a little bit a question of opinion and bearing in mind that reasonable people can disagree about the meaning of words, I think in that kind of situation, you need to be conscious of that as an appellate judge and very careful what you're doing.
Thanks, James. I don't know whether Stuart and Zhang Yu want to say anything about that. You both talked about live disputes at the moment and the role of scrutiny under international trade rules. And the question is, what's the role of deference for the member that's taking measures? And I think, Stuart, actually, you talked about that to some extent in your own presentation. You talked about the question of perceived threats by the US. And it is a difficult line, I think, for an international adjudicator to walk, that balance between scrutiny and deference. So I wondered whether, in light of the trade tensions that you both talked about, whether you wanted to say anything on this question of standard of review.
Well, I think it is an extremely delicate balance, as you say, Nick, particularly where we're dealing with matters of national security. And I think we have some evolving jurisprudence in this area as a result of a couple of recent cases. But one thing that does concern me is that if you have a case such as the one that I talked about involving US action against a very small member in terms of political clout like Hong Kong, I mean, how much deference is going to be shown to Hong Kong if its WTO membership is essentially being called into question? and how much latitude is going to be accorded to the United States in terms of the breadth of the threat that it feels that it's faced with. As I mentioned in my presentation, it's really quite difficult to make a case, I think, that Hong Kong threatens the US. As I said, you know, the US's largest goods trade surplus in the world is with Hong Kong, and Hong Kong is completely open. But to what extent would the WTO be looking at the threat that the US perceives from China being carried into the Hong Kong battleground, as it were? So this is quite a unique situation, I feel.
Very briefly, my personal view is I think many of those criticisms, although people can see some good reasons for that, legitimacy in that, but many of them are rather picky. I think the US is using some of those criticisms as excuse to violate WTO rules, and China might have been doing the same. And to me, that I believe the structure, the dispute settlement structure in the WTO has worked very well, and I have no doubt for sure there should be some technical improvements, such as, so for example, increase the members from 7 to 9. That sounds quite interesting and quite agreeable to me. But for those technical issues such as standard terms of reference, standard of review, and the even judicial activism, those issues can be resolved through better designed rules and institutions. I don't think they are fundamental problems. WTO agreements are only part of international agreements. We have part of the ocean of a sea of international agreements we have at the international level. So the international law. So this issue is not new to international law. It's not an alien question. So they're actually very good established practice to deal with this. I think some countries are just using those criticisms as excuses. So that's my personal view.
Thank you very much. I'm reminded of an observation I once heard from a judge at the Court of Justice in Luxembourg, who said that if we're not being criticized, then we're doing something wrong. And that's a reflection I've seen in all of the legal systems that I've worked in. So yes, it's I think a difficult line to walk, but wherever you walk on that line as a judge, you should probably expect some criticism. We have another question from the audience, which is to Professor Wang. And it was a remark that you made in your slide about the future and the willingness of WTO members to agree to a new set of rules. And you made the observation that some WTO members take the view that the current rules are not well adapted to China's unique economic model. And the question is, if China is ready for change of rules, as you suggested, then why doesn't China take the first step and offer changes and make proposals instead of waiting for the other side? That's also from Wolfgang Weiss.
That's really truly a wonderful question. My argument is, so my overall point is reform and opening up toward more liberalization and decentralization. It is the direction of China as the development of China as a state. So it's enshrined in the Chinese constitution, and it's enshrined in the development trajectory of China in the past few decades, and nobody can change it. Nobody can change it. So there have been, turmoils, there are ups and downs, but nobody can reverse this direction. So the overall direction of China's development is toward more liberalization. On that basis, I have two more points. The first one is sometimes people tend to underestimate the rapid rise of China's hard power. So and very few people actually anticipated such a rapid rise of the Chinese economic power. And on the other hand, people tend to overestimate China's soft power skills. So probably unlike the US and the European Union, China is not yet a rule entrepreneur. So it's used to be a rule taker rather than a rule maker. It currently probably doesn't have the capacity, doesn't have the pool of talents, and it probably doesn't even have the impulse to do this, to be a leader in rule making. Although the Chinese leaders have been encouraging China to be a rule maker, but it will take a lot of time. It will take some time. And the second reason is in the new areas, right? So China actually in the past 2 decades. Especially in China's accession to the WTO, China has been used to use international pressure to push for domestic reform. So you have international rules in place, then some more open mandate enlightened Chinese leaders like our former Prime Minister Zhu Rongji used the WTO accession as kind of pressure needed to push for his domestic reform agenda. The Chinese leaders might do the same. They might even want to do the same. So that's why, as I mentioned, they were seriously talking about joining TPP. Now there is a serious discussion. I'm actually watching this serious discussion within the establishment in China to talking about to make it possible for China to join CPTPP. So of course because of the tremendous vast domestic obstacles, right? So the objections, it's hard for China to. It's easier for the Chinese leadership to present this to its people that you see this is international best practice. You have international rules, and they were made in the fair way. So let's follow that. We have no choice. We have to follow that. So then we have to reform our state-owned enterprises, and we have to relax the restrictions on internet and those kind of things. Because of the domestic objections, it's unlikely for China to accept all the rules. But I believe China is willing to accept at least some of the rules. China is willing to negotiate. But it's hard for China to both from capacity perspective and from the political will perspective. It's hard for China to take the initiative. Thanks.
Thank you for those thoughtful remarks. And James, I see you. I'll come to you in a moment. I just wanted to offer a couple of reflections. First, I wanted to turn the question around and put it to the other speakers. And I appreciate they may not want to answer this question. But that is, if there are WTO members who see a need for new rules in order to address China's unique economic model, then should they be doing more to engage with China on this? So the question was, should China be doing more if it's ready for rule change? So on the other side, do you think that the system would benefit from a greater level of engagement with China from the other side, and is that possible? And the second observation I wanted to make was that I think that Professor Wang has just given us an illustration of James's statement that dispute settlement is a win-win in recognizing that there are sometimes domestic constituencies within members who need the push from the outside to lead to further reform. And that's, I think, one of the values of dispute settlement. But I think we can go for 5 more minutes. But Stuart and James, if either of you would like to make observations on those topics, then please go ahead. And James, I see you're champing at the bit, so please go. And then Stuart, you can have the last word.
This is what I mean about misinformation, and the devil is often in the detail. So the burning issues under the subsidies agreement are the meaning of public body and entrustment and direction. So if you actually read the case law, what it says, it declines to read into the treaty a reference to a majority or relative majority shareholding, because that's not there. But the case law states very clearly that if the country that's conducting the CVD investigation, or for that matter, the complainant in a case under Part 3, is confronted with a majority or relative majority shareholding and puts questions to the interested parties in the investigation or the interested member, frames those questions in an appropriate way in order to achieve transparency about other factors that might be relevant to the question, does not receive fulsome answers to those questions, is therefore entitled to proceed on the basis of the information that it has, or if it would be a panel under Part 3 of the SCM agreement to do the same thing, and reach the conclusion that it is indeed looking at a public body, with the consequence that the actions of that body will be attributable to the state, and so we will move on with the analysis under the subsidies agreement. Without a shadow of doubt, other WTO members have not significantly made use of this particular line of analysis. So it does raise a question in your mind. Everybody likes to make a big fuss about this issue, but why don't we use what we've already got? Exactly the same thing is true with entrustment and direction. You do not need a piece of paper signed by the minister entrusting or directing the firm. You can look at all of the evidence, you can build your case. Look at a case like ECD rounds as a very good example. No direct evidence. You build your case on the basis of indirect evidence. You challenge the other side to answer correctly framed questions. If you don't get a good answer, you draw the reasonable conclusion that there is entrustment or direction, and so you can continue with the subsidies agreement. So I am strongly of the view that the members have used less than 10% of the possibilities that are available to them under the existing rules. Why? Because it's an excuse. Let's not make it political excuses. Let's use the legal instruments available to us to address the problem that we say is there.
Thank you, James. Stuart, last word.
Thanks, Nick. Yeah, I think your question was, whether WTO members who see the need for new rules to address China's economic model could have done or could do more to take this up with China. I think they have done so to a degree, but I think it's tended to be rather megaphone diplomacy. And unless either side can see some opening that could be exploited and widened, then maybe that's difficult. If things were to change at a general level, and if China were to have the impression that major trading partners who think like this are amenable to a discussion which could end up possibly in a landing zone that might be acceptable to China in the long run, then that might change. But I don't think at present China sees that trading partners are really looking for a landing zone which it might be able to accept. It all runs back to the very unoriginal thought that unless we can find a way to free up trade negotiations in the WTO and find some new structures within which we can reach agreements, then nothing will happen, or very little will happen. And the age-old argument about judicial activism and making new rules through the dispute settlement system will continue, sadly. So I think this leads on to the general question of how we free up the system to allow negotiators to produce results in terms of new rules. And that's a conundrum, of course.
Thank you very much. Thank you, Stuart. Thank you, Professor Wang. Thank you, James. Stuart has left our discussion with a very big question. I'm afraid that we don't have time in this session to take on that question. We close the session now, and it's in Geneva, at least, it's 6 minutes past 11, and I understand that the next session will begin in 9 minutes, 11:15. And with that, I hand the floor back. Thank you very much to the audience, to the speakers, and to BIICL for organizing this excellent event.